Picture this for a second. You've spent years, blood, sweat, and tears building a highly successful company in Mexico. You've got a rock-solid team, loyal clients, the revenue is flowing, but then an employee makes a rogue decision, or maybe a complex accounting error just slips through the cracks. Suddenly, you're not just looking at a hefty fine. You are staring down the barrel of the literal dissolution of your entire company by the state. We're talking about the corporate death penalty. Welcome to This Explainer. Today, we are unpacking the ultimate threat to any company operating in Mexico, and much more importantly, how you can build the legal armor you need to survive it. We are talking about the corporate shield and how to navigate the deep, sometimes treacherous waters of Mexican compliance. So, let's dive right in. Here is our roadmap for today. We're going to cover 1. The concept of compliance, 2. Criminal liability of companies, 3. Consequences and imputable crimes, 4. Fiscal and accounting obligations, 5. Anti-money laundering prevention, and finally 6. Mitigation and best practices. All right, Section 1. El concepto de compliance. I know. Whenever people hear the word compliance, there's a collective eye roll. We immediately brace ourselves for another painfully boring HR training module. But if we look at this definition from legal scholar Carlos Verduzco, we see it is so much more than that. Compliance is actually a mandatory internal co-governance system. It's this robust set of procedures and good practices designed to actively pinpoint and neutralize operational and legal risks before they explode. In Mexico, this means your company basically has to act like its own mini-government, creating internal laws that legally protect the business from the inside out against criminal, labor, and fiscal threats. Moving right along to Section 2, Responsabilidad Penal de Empresas. Let me pose a pretty provocative question to you. Can a company, a non-human legal entity, a piece of paper essentially, actually commit a crime? For decades, the old-school legal mindset was absolutely not. Only human beings, the directors, the employees, could face criminal prosecution. But under the Mexican National Code of Criminal Procedures, that reality has radically shifted. Article 421 of the CNPP explicitly answers our question with a resounding yes. A company is independently liable for crimes committed in its name or for its benefit. But here is the absolute crucial trigger phrase: when it has been determined that there was also a lack of due control in its organization. That means your company is on the hook if it lacks due control, and that is completely regardless of what happens to the human administrators. Literally, even if your rogue employee flees the country and escapes justice, the state can and will prosecute the company itself. Which brings us to Section 3, Consecuencias y delitos imputables. The legal remedies a judge can apply here are frankly terrifying. During an active investigation, they can slap you with provisional measures, things like immediately suspending your activities or just padlocking your offices. But the final penalties, those are the real nightmare. A judge can order the total seizure of your assets. They can order judicial intervention, which is essentially the state stepping in and taking over the management of your business to safeguard creditors or workers. And the absolute worst-case scenario, corporate dissolution, the legal execution of your business where the state completely revokes your right to exist. Now, you might be thinking, come on, my company would never commit a crime that warrants dissolution. We're not criminals. But the Federal Penal Code, specifically Article 11 bis, lists a massive, sweeping catalog of crimes imputable to companies. Sure, terrorism is on there, but look at the everyday risks. Fraud, cohecho, which is bribery, tax defraudation, money laundering. It even drills down to copyright infringement and environmental crimes. A simple hazardous waste spill by one of your third-party contractors, or maybe a slightly too aggressive accounting maneuver, can spring a legal trap that puts your entire corporate entity on trial. Let's shift gears a bit. Section 4, Obligaciones Fiscales y Contables. So the fiscal code really forms the baseline of your everyday corporate compliance, and under Articles 27 to 29, it is incredibly rigorous. We are way beyond just registering your RFC and grabbing an e-signature. You have to meticulously update your shareholder registry and explicitly identify to the tax authority exactly who holds effective control of the company. You've got to maintain electronic accounting that is immediately accessible right at your tax domicile, and you have to issue, verify, and digitally stamp every single transaction through digital invoices, the famous CFDI. The state is demanding total real-time transparency regarding true ownership and cash flow. And keep in mind, compliance scales directly with your size. While every single company faces those rigorous baseline duties, Article 32A dictates that massive corporations, meaning those with accumulated income over roughly 1.77 billion pesos, or those with publicly traded shares, face mandatory external auditing and dictamination. Simply put, the bigger your footprint, the heavier your shield needs to be.
Section 5. Prevención de lavado de dinero. The anti-money laundering battleground.
Under Article 17, the law strictly defines what they call vulnerable activities. These must be tracked and reported. Now, we all know banks have to track money, right? But the sheer sweep of this law is what catches people off guard. Exchanging crypto, running an art auction, selling armored vehicles, real estate development, or issuing prepaid cards. Even outsourced professional services, like an independent accountant managing bank accounts for a client or setting up a corporate vehicle, are heavily regulated under this framework. This law aggressively polices everyday commerce, way beyond just the traditional financial sector. If your business engages in literally any of those vulnerable activities, Article 18 hits you with a dense set of rules, but we can break it down into a highly actionable, sequential checklist. Step 1. You absolutely must formally identify your clients using official documentation. Step 2. You have to dig deeper and ask if there is a dueño beneficiario, the beneficial owner, the true wizard behind the curtain, and you need their documentation too. Step 3. You must safely custody and lock down all of this documentation for a minimum of 5 years. And listen, failing to do this doesn't just mean an annoying administrative fine. It means you are completely failing your AML compliance, which can instantly trigger those exact corporate criminal liabilities we talked about earlier.
Finally, Section 6. Atenuación y buenas prácticas. Let's talk about the light at the end of the tunnel.
There is some very good news here. The Mexican Supreme Court has established vital jurisprudence protecting the presumption of innocence for businesses. They've drawn a very hard, distinct line between a legally constituted company and an organized crime group. Just because one rogue representative commits a crime, the state cannot retroactively presume that your entire legally formed business was just some illicit criminal syndicate right from the start. Your corporate structure, if it's legally and properly maintained, separates you from the cartel label. But to actually get that protection in a courtroom, you have to prove you actively tried to stop the crime. Which leads us to the ultimate statutory incentive in the Penal Code. If the absolute worst happens and your company is actually found liable for a crime, the judge has the power to reduce your sanctions and penalties by up to 1/4, a massive 25% reduction. But there is a huge catch. You only get this discount if you can clearly prove your company had a permanent, functioning control organ in place prior to the crime occurring and that this organ was actively verifying legal compliance. You cannot build the shield after the arrow has already been fired. It has to be proactive. All of this really leaves us with one final, vital question to reflect on. We've seen the sheer, crushing weight of Mexico's penal, fiscal, and anti-money laundering codes. We've seen exactly how a lack of due control can literally lead to the execution of your business. So I urge you to take a hard look inward at your own operations. Is your compliance program a living, breathing co-governance model? Does it actively monitor risks, safeguard your data, and hold people accountable? Or is it just a dusty binder sitting on a shelf somewhere? Because in the eyes of the law, when the pressure is on, a paper shield won't stop a steel blade. Thank you so much for joining me for this explainer, and we will catch you on the next one.